In response to the jury's note from 4:30 p.m. yesterday, the court will proceed with its original approach to refer the jury to page 37, lines 1 through 3, which answers the question directly asked by the jury. United States v. Cummings, 320F, Apps 317, 319, Second Sir in 2009, holding that the district court did not err, much less abuse his discretion in responding to the jury by rereading the relevant portions of the jury instructions. The defense's proposal to simply refer to the entirety of the instructions on the drug distribution offense is non-responsive to the very direct and precise question asked by the jury. It would also introduce confusion and potentially mislead the jury by suggesting, without any guidance, that the answer lies elsewhere, but where no one knows, in the instructions. As to the government's suggestion to simply answer the question yes, the court does not believe that this would be appropriate, and this approach was not adopted by the court in Cummings when a similar situation arose. As for the government's alternative suggestion based on United States v. Wallace, 532F 3126, Second Sir in 2008, the issue there was whether a sale was required for distribution, and the court held that it was not. But Wallace's reference to sharing, that wasn't really the issue in Wallace, and it is not responsive to the question asked by the jury anyway. And as Wallace itself recognized, there are prior cases, like United States v. Swiderski, 548 F. 445, Tutsert 1977, that the court and parties would have to potentially address if a supplemental instruction based on Wallace was provided. For those reasons, the court will respond as it initially indicated. We have a copy of the letter that we will send back to the jury. The court's law clerk will provide that to each side for them to quickly review, and then we'll get the response back to the jury.
Your Honor, may I be heard? I want a supplement. We haven't had a chance to actually be heard. I know Your Honor sent us an email.
You have had the chance to be heard. There was an email received by the court last evening at 6:30 p.m.
But I'm afraid that the court, and I say this most respectfully, is about to make something that amounts to a mistake, and let me tell the court why. First, I believe we're doing something that Your Honor has told the jury not to do. On page 1 of the court's instructions, Your Honor told them, you should not single out any instruction as alone stating the law, but you should consider my instructions as a whole when you retire to deliberate in the jury room. I believe we're not following some part of the court's instruction. Second, if we look on page 36, that's where Your Honor told the jury the elements of distribution. So I don't see how Your Honor could answer a question about distribution where on page 36, Your Honor says, starting at line 17, the elements of distributing or possessing with intent to distribute are as follows. And then Your Honor gives 3 elements. So Your Honor has given this jury 3 elements for distributing or possessing that Your Honor's now indicated you're not going to read to the jury.
Because that's not the question that the jury asked. Have you looked at the question that the jury asked?
I have studied the question that the jury asked.
Look, you see the copy of the note.
I've memorized it.
The court's law clerk provided you with a copy of the note.
I will pull it up.
You don't need to pull it up, because we have a paper copy for you to look at.
I have it. I have it in front of me.
Okay, and...
Oh, you want me to now? I got it.
You have what I've just indicated, and you have my proposal. Now, based on what you said, you want to make sure that the jury is not somehow confused, and I don't think there's any basis for confusion. To think that that's the only part of the instruction they should consider when looking at the distribution offense. That's what you're saying, all right? Well, that could be easily resolved by simply adding in one sentence at the beginning that says that the jury should consider the charge as a whole. And for this offense, it's reflected on these pages. In particular, the court refers to these lines and it provides those lines. That's a simple fix. If you want to do something along those lines, I don't have an objection to doing that. However, I have an obligation to directly answer the jury's question, and, consistent with Cummings, to provide them with a direct answer to direct question that the jury asked, because I am not permitted and it would be improper for me to leave the jury at sea when they have asked a direct question. So I'm willing to add in the sentence that makes clear that the jury should consider the charge as a whole, which is what you've referred to. However, for the reasons that I've just explained in detail, I do need to refer them to particular parts of the instructions, consistent with Cummings, consistent with what the Second Circuit has said, to make sure that they understand what they need to do here. Can you do that?
I don't think it goes far enough.
It doesn't matter if you think it goes far enough. Can you do what I'm asking, or do you not want to?
No. I'm trying to work with Your Honor. I'm not trying to throw up roadblocks.
Then answer my question. Can you do what I'm asking, or no, you can't do what I'm asking?
Of course. I can, of course, do what Your Honor's asking. But can I give Your Honor an example?
No. Can you do what I'm asking, because I've just listened to you, and I've heard what you said, and you said you're concerned, and I don't think the concern has any basis, that somehow the jury's going to think that that's the only part of the instruction to consider in general terms. The jury's not going to think that. The jury asked a very, very specific question, a very precise question. I've reread it again just 2 minutes ago, very specifically referring to this page in the instructions and referring to a question that the jury had. And so if I don't provide them any kind of guidance on how to answer that question, without even referring them to a particular part of the instructions, that would be potentially confusing. That would be potentially misleading, because it might suggest to them that they should look elsewhere for the relevant instruction without any guidance on how to find it. However, I don't think it does any damage to remind them in the way that we've reminded them previously that, of course, they should always consider the instruction as a whole and not single out any particular part. But I do want to refer them to those lines. That's why I'm asking you. Do you want to put in an extra sentence along those lines? I'm happy to consider it.
Your Honor, may I be heard on that point?
Yes.
I don't know if Mr. Agnafilo's done. Thank you, Your Honor. My concern with referring to the instruction as a whole is that this is a question about a single element. This is not a question about the charge as a whole. This is not a question about whether, in the hypothetical, in the note, the individual would be guilty of violating 21 U.S.C. 841. It is a question about the element of distribution. My concern about referring to the charge as a whole would be that it would be misleading and confusing for the same reasons Your Honor just articulated. They're asking about the element of distribution. The charge as a whole includes charges for 2 other crimes separate from distribution. It includes possession with intent to distribute and conspiracy, which are not responsive. And I am concerned that a general reference back to the whole charge would get us back to the level of confusion and being misleading that Your Honor was concerned about in the first place. So perhaps couching it and saying with respect to element of the distribution, you should refer to these lines, because that would make clear that the court's response is cabined just to that element. But my concern about referring to the instruction as a whole is that would invite the same confusion and be misleading in the same way that Your Honor was concerned the defense's proposal would be.
I agree with Ms. Comey here. We need to get an answer back to the jury. So I'm happy to sit here. If you have a proposal for me that's consistent and respects what Ms. Comey just said and what I've said, then I'm happy to consider it. But I do think we need to isolate that element, for the reasons Ms. Comey said. If you want to further say in general terms, or you should always consider the charge as a whole, if you want to put in language on that to address your concern, I'm happy to take a look at that, and Ms. Comey will take a look at it as well.
We will do that.
All right, let's take a couple minutes. I'll sit right here. I'll wait, and we can get a response back to the jury.
And we're not waiving our objection.
Understood. While we're waiting for the defense to put in their proposal, Ms. Comey, can I ask you to have someone on your team make sure, consistent with what I've previously ordered, to make sure, to the extent there are emails that have been filed that were not reflected on the docket, to just collect those and make sure they're reflected on the docket?
Yes, Your Honor, we'll do that.
Your Honor, we have applied for proposed redactions. I think there's only one email on our side that has not been filed and a few letters. We've sent those to the government. They should be reviewing those today, and they should be on the docket while we work.
Your Honor, I have the defense's proposal, which I'll hand up. I'll note we object to it.
All right. I have the defense's proposal. For the reasons I've previously stated and for the reasons stated by the government, I reject the defense's proposal. You've made your objection. It's on the record. But I believe that this proposed revision would confuse the jury as to the very specific question that was asked. And so we'll provide the note with the response to the jury, and we'll proceed and see if we have any other further questions.
Your Honor, could we just put one thing on the record? Because we do believe that the rules about joint and constructive possession actually are relevant for the jury's question here. And I would just direct the court to United States v. Wallace decision. It states, in sole possession in such a case would rest with the defendant. His transfer would violate the prohibition on drug distribution. And there, the issue was whether the defendant had sole possession. So, directing the jury just to this definition of distribution would mislead them.
In what way? This was the language that was agreed upon by the parties. This language was not objected to by either side. This was the unobjected to language. Hold on. This was the unobjected to language pertaining to this issue that the parties agreed would be provided to the jury. All we're doing is referring the jury to that part of the instruction. Is there another part of this instruction, of the jury instructions provided that I read here for 3 hours yesterday, that pertains to the specific issue that the jury asked about? If so, which lines?
Yes, Your Honor. There is a different portion of the instruction because...
Which lines?
1 second, Your Honor. On page 38, lines 3 through 7.
Your Honor, those lines relate only to possession with intent to distribute. This is an attempt to mislead the jury. Your Honor's proposed instruction is not erroneous in any way. It is legally correct, and this is an attempt to mislead the jury, Your Honor.
But, Your Honor, the rules for distribution...
Hold on, you said page 38.
Yes, lines 3 to 7.
All right. As the government notes, this has to do with the separate issue of possession, and it relates to possession with intent to distribute. Again, the jury has given us very clear guidance as to the question that they have. They've referred to the page number. They've referred to the specific element that they had a question about. And we are referring to the agreed-upon language referring to that particular element. Referencing this language or referencing the entirety of the drug distribution instruction would be misleading. You've put it on the record, and you've made your objection. We'll proceed as the court had indicated. Anything further from the government?
No, Your Honor.
Anything from the defense?
Judge, could you just mark our handwritten proposal as a court exhibit?
Yes, we will make it a court exhibit. Anything further, Mr. Agnifilo?
No, thank you, Judge.
All right, very good. We are adjourned. Please be seated. All right. I know the parties are working on a proposed response, but just for the record, we received a note from the jury at 10:15 a.m. today that reads, "We would like to review the following elements of testimony transcript. 1. Cassandra Ventura testimony regarding Intercontinental Hotel incident. 2. Cassandra Ventura testimony regarding Khan and the events immediately following. 3. Cassandra Ventura testimony, if any, regarding interactions, freak-offs with Daniel Phillip. And 4. Daniel Phillip testimony regarding Essex Hotel incident with Cassandra Ventura. I'll start with the government. Have the parties had a chance to confer as to the transcript or testimony to provide to the jury?
Yes, Your Honor. We are mid-conferral. We have reached agreement with respect to Mr. Phillips' proposed testimony, and we are printing out copies of redacted excerpts of his testimony as we speak. I believe we have reached agreement as to one of the 3 sections of Ms. Ventura's, and then with respect to another one, I believe it's the cans incident. We've reached agreement with respect to everything except for 2 lines. The government believes there are 2 lines that should be included. The defense believes they should not be included. And the Intercontinental is quite sprawling, so we are working on finding all of the references to the Intercontinental incident throughout all of Ms. Ventura's testimony. So I think right now what would be helpful is to tee up for Your Honor the one small dispute with respect to Khan.
Very good.
And I'll defer to Ms. Johnson to tee that up for Your Honor. Oh, I'm sorry. Ms. Johnson may not be the right person.
Before we address that, just a procedural question. Does either side want me to bring the jury out to read them the note and then tell them what we are planning to send back or that we are planning to send materials back? To date, neither side has had an issue with responding to the jurors in written form. However, if either side wants me to, I'm happy to bring the jury out to read the note into the record and then tell them what we are going to do. So as to this note, let me just ask the government. Do you have a desire to have the jury brought out for that purpose?
No, Your Honor. We'd have no objection to that if the defense would like it, but we don't see a need.
Mr. Agnifilo,
I've conferred with Mr. Combs and the rest of my team. We don't need to bring the jury out.
all right. And then is that also? We've had 2 prior notes. I just want to confirm that neither side would want me to bring the jury out to read them the notes and to read them the court's responses. Ms. Comey.
Correct, Your Honor. Our position is the same.
Ours is the same, Judge.
All right. As to any future note, if either side wishes that I bring the jury out to read them the note and the response after we've discussed it here, I'm happy to do so. With that, Ms. Comey, you were going to defer to a member of your team.
Yes, Judge. On point 2, the jury requested testimony on the events at Kane and, quote, the events immediately following. The parties are in agreement as to 3 of the 4 sections of transcript to provide the jury. Our disagreement is just in the last section, which is in redirect. I don't know if the court has the capability of pulling up the transcript, but it's page 1315. Or I don't know if our paralegals could do that.
I think I can, but if you have it. 1350.
1315, 1315.
I have all the transcript excerpts except for that particular one. I'm sure I could find it in 1 minute, but if you have it.
I think we're working on it. It's 1315. Sorry.
What's the date of the testimony?
It's on the screen now. Can the court see it?
Go ahead.
The jury note asks for cans and the events immediately following. It's the government's position that the question, what happened when Sean was angry, and the answer on lines 21 and 22 is a follow-up to Miss Ventura's response in the previous lines. It relates to the freakout that occurred immediately upon landing in New York, and the government thinks that should be included in the portion of transcript that goes to the jury.
And this is the end of the discussion.
Yes.
I said con, but apparently I'm wrong.
It's our position that this is the end of the discussion, and then line 23 moves to a new topic of discussion. I'll let Ms. Garagos speak, but I understand the position of the defense is that this is a more general response that shouldn't be included. But it's our position that this is a follow-up to the discussion of the freak-off that happened and the events leading to that point.
I'm looking at this, and I would likely cut the testimony off at line 20. So if the dispute is about line 21 and 22, I would exclude that from what goes back to the jury. But I'll hear from Ms. Garagos.
I have nothing to add, Your Honor.
And any other disputes or issues to address in terms of what goes back to the jury.
Not on this issue. I imagine we would need to speak to the court about the Intercontinental, but we would like a few more minutes to work through the transcript.
Please let the deputy know when we're at a point when we can resolve that, and I'll come back. Thank you very much. Please be seated. I understand that there's an issue to resolve.
Yes.
What is the issue?
I understand that during the break, the defense came up with an issue regarding Daniel Phillip, so I'll let the defense raise that, their issue.
Is there also an issue concerning time frame, or have the parties resolved that issue?
We still have that issue as well.
All right, so let's address the Daniel Phillip issue first.
Yes, Judge. We have looked at question number 4, which says Daniel Phillip testimony regarding Essex Hotel incident with Cassandra Ventura. We are in agreement with everything except for pages. Page 283, line 11 through 16. The government believes that question and answer should come in, or the government believes that's responsive. We believe that it is not.
Can you give me that transcript page?
Page 283, line 11 through line 16. That includes the question and answer. We are suggesting that that does not, or is not responsive as it relates to post-thought processes by Mr. Phillip related to the incident, not regarding the actual incident. So that's our position. The government's position, the question is asking what he thought about or why he didn't do something after the incident, does respond to the question, which is asking to tell them about what happened during the incident.
Your Honor, our position is the request is for Daniel Phillip testimony regarding Essex Hotel incident with Cassandra Ventura. That question and answer are regarding the Essex Hotel incident with Cassandra Ventura. I don't see the problem with providing this testimony, which is regarding that topic and which was admitted at trial.
All right, and we're not going to include lines 16 through 18.
Correct, Your Honor. We've redacted those, which Your Honor struck from the record.
All right. So the testimony at issue pertains to the incident that's being discussed in the preceding passages.
Exactly, Your Honor.
All right, so that testimony will be included. Next.
Point 1 that the jury requested is testimony of Cassandra Ventura regarding the Intercontinental Hotel incident. It's the government's position that that incident is what occurred at the hotel the evening of March 4 into the day of March 5. There is testimony in the record about events starting several days before and text messages starting several days before and text messages that go after the incident. So we're looking for some guidance from the court. It's our position that it should be the incident at the hotel, that's what they're looking for. In addition, the defense also proposed including Ms. Ventura's testimony about her Instagram post from 2024, after the video was publicly released, which we think is not responsive to the jury's request. And they also marked her testimony about her settlement with the Intercontinental Hotel, which we also think is not responsive to the jury's request.
All right, let me hear from Ms. Garagos.
Thank you. We have proposed parts of the testimony, Ms. Johnson said several days before, but there's a government exhibit which Your Honor recalls is the "I want to freak off so bad" from Ms. Ventura. On our cross for completeness reasons, we introduced 1,088. I think the defense exhibit number was, and it's just the beginning of that conversation. It's Ms. Ventura reaching out to Mr. Combs while he's sick, and we believe that it is essential to the entire Intercontinental incident because it's hard to kind of parse the testimony as to when the planning of this alleged freak-off started without having the testimony related to both of those exhibits, which is why we included testimony starting from the defense exhibit 1,088 messages. And so we had proposed that testimony regarding those messages be included in the response to the jury note, question number 1. We did not include any of the testimony regarding Ms. Ventura when, after she left the Intercontinental, her testimony about going to her home, Mr. Combs going to her home, Ms. Coram and D-Rock, etc., because we don't believe that that's directly responsive to question. No. 1. Regarding the hotel incident, because it is at that point that she leaves. But we did include then testimony regarding several messages from after the Intercontinental incident, when they're talking about the Intercontinental incident, her and Mr. Combs. So, because the question is specific to testimony regarding Intercontinental Hotel incident, we did include testimony from several days afterwards between where she's talking about conversations between herself and Mr. Combs because it's regarding that incident. So that is the reason for our proposal that has some testimony regarding about a day and a half prior, because we believe that that's when the planning of that freak-off starts and is essential to the jurors' understanding of whether Mr. Combs coerced Ms. Ventura into commercial sex on that date. And then we did include some testimony, limited, but between that Ms. Ventura testified to about her conversations with Mr. Combs several days after, because we believe that that is also relevant to whether Mr. Combs coerced her on that date to engage in commercial sex. And then there are the two disputes regarding the settlement, which has to do with the Intercontinental incident, and the Instagram post, which also has to do with the Intercontinental incident. So that's the reason for our proposals.
Focusing on the last two issues, can you just remind me, how does the post regard? The request was for Ms. Ventura's testimony regarding Intercontinental Hotel incident. So how does the 2024 post regard that incident in a more direct way than, for example, the aftermath of the incident itself? When Ms. Ventura went home and Mr. Combs went to her house, all that testimony.
I think because the exact question posed to Ms. Ventura was, you recall posting on Instagram after the video of the Intercontinental Hotel was aired in May of 2024, so it's a direct response to the video of the incident at the time. We are including in our proposals her testimony regarding watching the video in court, and so we think it just completes that testimony. It's all of her testimony regarding reactions to the video.
All right. Then as to the settlement, the fact of the settlement doesn't have to do with the incident itself in the way that you've articulated, which is that you want to include what you believe fairly is Ms. Ventura's testimony regarding the incident. And so you have the communications before the incident. You have the communications after, and you say the 2024 post. That post featured in the questioning, and Ms. Ventura explained the relationship of the post to the incident through the video, obviously.
Yes.
So the settlement is, you'd agree, a few steps removed, meaning it's just the fact of the settlement.
We're withdrawing the settlement, Your Honor.
All right, as to the other, I'll hear from Ms. Johnson.
Your Honor, starting with her comments on Instagram in May of 2024, it's not at all clear to me from the testimony. It just says, you recall posting on Instagram after the video was aired, and it's discussing snippets of what she posted on Instagram after this video became public in May of 2024. The focus, of course, is that she wrote, among other things in her post, that domestic violence is the issue. I don't think this has any relevance to what the jury's asking about, and if the argument from counsel is that putting in wide swaths of testimony is important to assessing Ms. Ventura's coercion, the government would submit that the 2 lines excluded from the comments are critical in assessing coercion. And in addition, the lines that the defense excluded from what happened after the Intercontinental incident is also critical.
Ms. Garagos, what is the actual questions and answers that you want to put in regarding the 2024 post? Do you have a page number?
Yes. It is on transcript page 1294, line 12, to transcript page 1295, line 9.
All right, so can you show me the testimony as to the events preceding and the events postdating the incident that you would also want to put in?
Sure. I think I'll start at our first dispute. I think that makes sense. But that is the postdating. We all agree to start at transcript page 629, line 15. The first dispute begins at transcript page 639, line 16. And we believe that it should end there. The government, I believe, thinks that it should go on for about 10 pages, so perhaps we could start there. I don't know if Ms. Becker could pull up the next page, or Mr. Gavin. Thank you. We proposed ending at line 16 on that first part of the page and where she says, I actually don't remember having any conversations with him after, until there was like another freak-off, honestly. And then it goes into, if Your Honor recalls, the selfies that Ms. Ventura took of herself, and what starts happening in the quote-unquote aftermath of the incident that the government believes should be included, that we do not believe should be included. But I don't have the exact page number. Perhaps Ms. Johnson could put on the record.
We would go to 649, line 21. But again, if we are making the beginning more narrow, we can make the end more narrow.
So maybe we should start there. Let's start with our second dispute.
The second dispute is more significant, which starts at 1091.
Yes, 1091, line 11. And if we could put those 2 pages, this is where we believe that it should start, which is 625, because that's the government's exhibit that is kind of the critical government exhibit here as to the beginning of the Intercontinental freak-off. So the way that this part of the transcript reads is it goes through that part of the government exhibit, and then we're going to go back into Defense Exhibit 1088, which is the one that Mr. Agnifilo quoted in his summation.
All right.
The government would propose excluding the discussion of 1088, which relates to a completely different day. It starts on March 3. There's discussion in the record that it's on March 4, but if you look at the exhibit, it's in UTC time, so it's actually March 3.
Which is reflected on line 24, but the conversation starts then. Just because it's on a different time period, there's no break really in the conversation. If we go, maybe, if Your Honor's okay, if we could go forward 2 pages to 1095 and 1096.
Why wouldn't we just provide the jury? So let me take a step back. So the jury has 3 categories of testimony from Ms. Ventura that they're asking for. And there are some disputes about where exactly to cut off the testimony in response to the jury's questions. But why isn't at least one option to simply furnish the jury with the entirety of Ms. Ventura's testimony so that they can look at what they want to?
That's also fine with us.
One moment, Your Honor. Give me one moment, Your Honor. Your Honor, we prefer to answer the juror's direct question and not provide them the entirety of the testimony. And I think it's for multiple reasons. First, this is for 4 days of testimony. It's lengthy. It's almost 800 pages. There's no search function when you're just looking at a printed PDF, and so we're concerned that they would not be able to properly find every single part of the testimony regarding intercontinental testimony, and there's a lot in there that's just not relevant to their direct questions. So we would just prefer to answer their direct question and provide testimony just regarding the intercontinental.
On the logistics, if the court would allow us to briefly take the laptop from the jury, we could load a searchable PDF onto the laptop. So that would address the searchable issue. We could give them a paper copy and load a searchable electronic copy onto the laptop.
Understood. So the defense can consider that. I think that alleviates some of the logistical issues. The jury's question did not go to any particular element, so I don't think it's appropriate to try to address whether particular testimony would go to the issue of coercion or any other element. I think the question is, as framed by the jury, whether they're looking for the testimony going to. That is regarding the intercontinental incident. And I understand from you, Ms. Garagos, that the messages before and after the event go to the incident, because it is directly addressing the events that took place during that incident. And so I would agree that those messages should be included in what is given to the jury. As to the few lines regarding the 2024 post, I think that can be included as well. I don't know that. It's neither here nor there. But the questioning as it was phrased was directed to the post and its relationship to the intercontinental incident, because it was discussing or in the wake of the video, so I think that's fine. You've withdrawn your request as to the settlement questioning. So then what is left? Given that framework, what is left to address?
I think that the government would propose including the messages if we're including messages post-dating the incident, which the defense has marked, some of which are several days later. Then the government would want to include the messages that start after the video and continue throughout the day of March 5, all of which directly relate to what happened in that video, and her testimony about the pictures of the injuries that she had, which includes the pictures she took in the car and injuries she had at the premiere.
And Ms. Garagos, in fairness, for the reasons that you've articulated as to why the post-event messages regarding the incident would be relevant, then that same category would also be applicable to what the government wants to put in. If there are communications or testimony about communications that regard the incident or injuries that Ms. Ventura sustained during the incident, those would fall into the same category. I'm not hearing from Ms. Johnson that she is pressing on testimony concerning the aftermath or what happened afterward. Right, Ms. Johnson? You previously were.
No, I still am. The messages from March 5.
Put that to the side. Put that to the side. You're saying separately if Ms. Garagos is putting in messages regarding the incident, then you should be able to answer that with the testimony regarding the incident in the same way. Just separate. We'll address the other issue next.
Correct.
Ms. Garagos, I don't know what the objection would be to that. You agree, right?
I think that with respect to... No, I think I will maintain my objection. I understand, Your Honor, but I think I just have to maintain my objection with respect to the photos. She testified she didn't remember taking them. And the events right afterwards when the ghost they don't over 20 de kier and concerning Mr. Combs's communications directly. But I understand Your Honor's position. But that was our position, confining it. We are confining it to the conversations she has with Mr. Combs about the incident and her testimony about the incident.
Let me ask the government, so this is for both parties. I had previously requested that the parties redact the testimony so that it could be quickly furnished to the jury. Has that been done as to Ms. Ventura's testimony?
It has, Your Honor. It's just, with respect to this particular incident, it's very difficult. And I do agree with Your Honor's suggestion that furnishing the jury with a copy of the entire testimony is the far simpler path.
I agree. Because with every line that I draw, Ms. Garagos, in favor of your introduction of some portion of testimony, Ms. Johnson is going to have a response as to additional testimony that, in fairness, should be considered when you look at that. And it's going to be impossible to get back to the jury. The better solution and the fairer solution is by providing the jury with Ms. Ventura's testimony generally. The jury will then have the ability to look at the entirety of that record, which they would be entitled to do anyway, because it's admitted testimony. We've redacted out anything that was not admitted, and that way we don't have to engage in this line-drawing exercise. where we're going to be going back and forth as to what testimony should be in and what testimony should be out. It is neutral and fair, and it doesn't favor or prejudice either side. It is true that the jury would have to look through the testimony, but I think that could be addressed by providing them an electronic copy, or by the jury simply looking through the transcript for the relevant places that they want to. And we can provide multiple copies of the transcript so that there are multiple copies in the jury room.
We would prefer, Your Honor, if that's the way Your Honor's leaning to withdraw on the photo testimony and have the few days before and few days after, rather than giving them 800 pages and having them see, and she testified about many things other than intercontinental incident, to give them the entire testimony when they're asking for something specific. We would really just prefer to have Your Honor's original leaning, which is a few days before, March 3, testimony about that, up until the few days after, and we think that that addresses the defense's concern, which is rather than giving them 760 pages of testimony, because we agree on the redactions, to confine it to the intercontinental incident, which was their direct question. So I'm withdrawing what I just told you was my objection and just asking it to be, that rather than engaging in the line-drawing exercise, we agree on the confines, a few days before and few days after, and giving that to them.
And that would include testimony within that time period that the government would want to put in.
Yes.
Okay, so I think then we have agreement, unless I'm missing something.
I do want to press the Instagram again, Your Honor. I respectfully understand the court's ruling, but I do not think this relates to the jury's question. They asked about the incident at the hotel. Her discussion and release of the public video I do not think is responsive to their question for her testimony. And I don't think it's relevant. I think it's confusing, and I don't think it should be provided.
All right, I understand. I think it's fair to include that portion, which is a very few lines of testimony that can be included. Otherwise, I want to make sure I understand. So, Ms. Garagos, maybe you can just... I believe the parties have agreed to make sure that there's no misunderstanding so that we can get the right testimony back to the jury. So on the Instagram post, that testimony that you identified on the record can be provided. As to the settlement, you've withdrawn your request to provide that to the jury. Otherwise, I believe we have agreement.
I'll say it again, which is...
Say it again.
We agreed. The testimony regarding a few, I'll say 2 days before, March 3, 2016, which is the testimony that we had proposed, begins on 1091, lines 11 to 1134, line 10, and then the testimony right after. So that would include what the government had proposed, which was, we agree on Transcript 629, line 15, through 649, line 21. And it would include also the defense's proposal, which I don't think we've shown Your Honor. But the testimony regarding messages between Ms. Ventura and Mr. Combs approximately 3 days after the incident regarding the incident.
And you've shared that with the government?
Yes.
All right, Ms. Johnson, so understanding that you object to the Instagram post testimony, just put that to the side the way that Ms. Garagos has articulated it. Is there any objection to providing that testimony to the jury?
I believe Ms. Garagos had also initially provided 1,162 to 1,170, and I want to just know what the position is on that.
Yes. This was 1,162, line 15, to 1,170, line 6 is exactly the kind of testimony I was just talking about in terms of her testimony about the intercontinental incident. It's testimony regarding a government exhibit and a defense exhibit from a few days afterwards, so we would propose that we include that as well.
Okay, I think that falls within the scope of the court's ruling.
We think if we could just put it on the record, 1,294, line 12, to 1,295, line 9. Sorry, the court ruled on it. I think we have worked out our differences.
All right, very good.
With the court's help, thank you.
All right, very good. If there are any further issues in terms of what is to be provided, let's do it this way. Now that we've had this discussion, the parties should collect that testimony. If there are any further issues that either side would like to raise, then please raise it with the deputy and we'll come back down. But let's try to get this testimony furnished to the jury by 1 p.m., so it's 2:30 right now. Let's try to get... I see a smile.
I'm sure Ms. Becker will be able to do it.
I think that we could probably furnish the jury with what we already have. Is that correct?
Yes, yes.
Which is the testimony in response to questions 2, 3, and 4.
All right, very good. So let's make sure that, again, both sides have reviewed, everyone's on the same page, subject to the rulings that I've made, and then we'll proceed on that basis.
Okay, great.
All right, very good. All right. With that, let's bring back our jury. Please be seated. Welcome back, members of the jury. Thank you for all your hard work. I've received your note that you have reached verdicts on counts 2 through 5, but not on count 1. I ask at this time that you keep deliberating. In doing so, I will remind you of the instructions I gave you yesterday. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. Each of you must decide the case for himself or herself, but you should do so only after a consideration of the case with your fellow jurors, and you should not hesitate to change an opinion when convinced that it is erroneous. Discuss and weigh your respective opinions dispassionately, without regard to sympathy, without regard to prejudice or favor for either party, and follow my instructions on the law. Again, your verdict must be unanimous, but you are not bound to surrender your honest convictions concerning the effect or weight of the evidence for the mere purpose of returning a verdict, or solely because of the opinion of other jurors. Each of you must make your own decision about the proper outcome of this case based on your consideration of the evidence and your discussions with your fellow jurors. No juror should surrender his or her conscientious beliefs for the purpose of returning a unanimous verdict. Thank you. At this time, I'll ask you to return to the jury room. If you are done for the day with your deliberations, you may send us another note, and we'll bring you back here very briefly, and you'll be able to go home at that time. Again, I thank the jury for all their hard work. Be seated. Everyone can go back to doing whatever they were doing. I'm only sitting here because we may get a note in the next few minutes. All right. We've received a note from the jury that they are completing their deliberations for the day and will resume tomorrow at 9 a.m. So with that, we will bring out our jury. Please be seated. Very briefly, again, thank you, jury, for all your hard work. I'll give you just a reminder of the instructions I gave you yesterday, which is I won't be bringing you out in the morning tomorrow, so you'll go directly into the jury room. Do not start your deliberations until all 12 of you are there. If all 12 of you are not there, then you can talk about the sports, weather, anything else, but not anything concerning this case. Also, remember to keep an open mind as you continue your deliberations, and no communications with each other about the case in the meantime until you recommence your deliberations. No communications with anybody else about anything concerning this case. And please do not watch, read, or look up anything concerning this case in the meantime. With that, I wish you all a great evening, and we'll be seeing each other tomorrow. If there's a note earlier in the day, it will be sooner than later. But I wish you a great evening, and we'll see you tomorrow. Please be seated. Anything further to address before we adjourn today?
No, Your Honor.
No, Your Honor. Thank you.
All right, so we'll see everyone tomorrow. Again, if there are any issues to address before the jury starts, let us know by this evening so that we can all come back early before the jury starts. Otherwise, have a great evening, everyone.